I inherited 900 acres from my uncle. I had no idea that for 11 years an HOA had been billing my tenants every single month, collecting dues on land that was never part of any HOA, never subject to any covenant, and never legally under their authority. They collected tens of thousands of dollars. They sent letters. They threatened liens. They acted with complete confidence. And not one person stopped them until I started reading documents. My uncle's name was Gerald. He was a quiet man. He farmed the same land his father farmed, and his father before that. He never joined anything he didn't have to. He never signed anything without reading it twice. He died in March 2 years ago, leaving no wife and no children. I was his only living relative. I live in a different state. I work in logistics. I manage schedules, not land. When the estate attorney called me, I thought it would be simple. A house. Maybe some equipment. A modest inheritance from a man who lived modestly. It was not simple. The estate included 900 acres of mixed land, pasture, timber, and 4 tenant properties along the eastern edge. The tenants had been there for years. They paid rent directly to Gerald's account. When Gerald died, that account transferred to the estate. I became the landlord without ever planning to be one. I hired a local property manager named Donna to handle day-to-day operations while I worked through the paperwork from out of state. That decision bought me time. It also delayed what I was about to find. For the first few months, everything seemed routine. Donna collected rent. The tenants stayed. The land sat the way it had always sat, quiet, wide, and unbothered. I visited once in May, about 8 weeks after the estate closed. I drove the perimeter. I walked 2 of the 4 tenant properties. I met one of the tenants, a man named Carl, who had farmed a portion of the eastern pasture on a lease arrangement for 6 years. He was polite. He seemed settled. He also seemed slightly nervous. I didn't think much of it at the time. Change in ownership makes people cautious. I understood that. I told him the lease terms would remain the same. He nodded. He thanked me. He went back inside. I spent 2 days reviewing the physical land. The fencing was in decent shape. The timber parcels were untouched. The access roads needed grading, but nothing urgent. I took notes. I photographed boundaries. I flagged a few things for follow-up. Then I drove home and returned to my regular job. For the next 3 months, I received monthly summaries from Donna. Rents paid, minor maintenance. Nothing unusual. I was beginning to think the inheritance, while unexpected, would be manageable. In September, I received a phone call from Carl. He asked me a question I did not expect. He asked if I had received the HOA's letter about the upcoming dues increase. I told Carl I didn't know what he was talking about. He went quiet for a moment. Then he said he assumed I knew. He said the HOA had been sending letters to the property for years. He said he had been paying dues every month, separately from his rent, directly to an organisation called the Creekside Community Association. I asked him how much. He said $85 a month, recently raised to $110. I asked him how long. He said since he moved in, 6 years. I did the math in my head. 6 years. $85 a month for most of it. That was over $6,000 from Carl alone. And there were 4 tenant properties on that eastern edge. I kept my voice calm. I told Carl I would look into it. I thanked him for calling. I hung up. Then I sat at my desk for a long time. I pulled out the estate documents. All of them. The deed, the survey, the title report, the property history going back 30 years. I read through every page. I was looking for one thing, any mention of a homeowners association, any covenant, any recorded restriction. Any easement or agreement tying that land to an organised association. There was nothing. Gerald's land was agricultural. It had always been agricultural. The eastern parcels had been converted to residential leases sometime in the early 2000s, but the land itself was never platted into a subdivision. It was never developed under an HOA framework. There was no declaration of covenants, conditions and restrictions, what attorneys call a CC&R, recorded against any portion of the 900 acres. None. I called the estate attorney the next morning. Her name was Patricia. She had handled Gerald's affairs for over a decade. I explained what Carl had told me. I asked her if she had any knowledge of a Creekside Community Association having any legal authority over the property. She was quiet for several seconds. Then she said she had never heard of them in connection with Gerald's land. I asked her to pull the full title chain and look for any recorded documents from that organisation. She called me back 2 days later. She had searched the county recorder's office. She found no recorded declaration, no recorded annexation, no recorded easement, no document of any kind linking Gerald's 900 acres to the Creekside Community Association. What she did find was a subdivision about 1.5 miles to the east. A planned development called Creekside Estates built in 2003, 94 homes, a legitimate HOA, recorded CC&Rs. The whole structure. Gerald's land bordered that development on its western edge. That was the only connection. The HOA had apparently decided at some point that proximity was the same as membership. They had been sending dues notices to the tenant properties on Gerald's eastern parcels for years. The tenants, not knowing land law, not knowing what CC&Rs were, not knowing they had any right to refuse, had paid every month for years. I asked Patricia what our legal exposure was. She said we had none. The land was never subject to their authority. The dues were collected without legal basis. She used a careful phrase. She called it an unauthorized collection of funds. I wrote that phrase down. I called Donna next. I asked her if she had ever received any correspondence from the Creekside Community Association. She said yes, regularly. She had assumed it was legitimate since it predated her involvement. She had filed the letters without flagging them to me because she thought I already knew. I asked her to pull every letter she had. She scanned and sent me 31 pieces of correspondence spanning 18 months, her entire time managing the property. The letters ranged from routine dues notices to late fee warnings to one letter threatening a lien on the property for non-payment by one of the other tenants. A lien threat on land they had no authority over. I read every letter twice. I organised them by date. I noted the tone. Early letters were administrative, neutral. Later letters grew more assertive. The most recent ones carried the signature of someone identified as the HOA board president, a name I would come to know very well. Margaret Hollis. I searched for the Creekside Community Association online. They had a basic website, a logo, a list of community rules, a contact form, a page listing board members with photos. Margaret Hollis was at the top. She had a formal headshot and a short biography describing her as a retired office administrator with 12 years of HOA board experience. 12 years. That number stopped me. Gerald had owned that land for decades. The Creekside Estate subdivision opened in 2003. If Margaret had 12 years of board experience, she had been involved since roughly the time the development was established. She had been part of this organisation from nearly the beginning, which meant she likely knew exactly what she was doing. I did not assume malice immediately. I have learned over the years that systems create their own momentum. It was possible that an early board member had made an administrative error, had included Gerald's tenant parcels in their dues list by mistake, and that error had simply never been corrected. Inertia is powerful. Bureaucracies repeat what they have always done. But I also noted the lien threat. That was not inertia. That required a deliberate decision. I contacted all 4 tenants directly. I asked each one the same questions. How long had they been paying dues to the Creekside Community Association? How much? Did they ever receive any documentation explaining their membership? Did they ever sign anything? The answers were consistent and troubling. Carl had been paying for 6 years, $140 a month currently, after multiple increases. He had never signed any membership agreement. He had never received a copy of any CC&Rs. He had received a welcome letter when he first moved in on Creekside Community Association letterhead informing him of his dues obligation and payment instructions. A welcome letter, as if membership were automatic. The second tenant, a woman named Rosa, had been there for 9 years. She had been paying $70 a month when she arrived, now up to $110. Same story. No signed agreement. No CC&Rs provided, just a letter telling her what she owed. The third tenant had moved in 4 years ago. He showed me a letter he had received in his first week. It was professionally formatted. It listed the property address. It listed the dues amount. It told him payments were due on the 1st of each month. It said failure to pay could result in fines and liens against the property. He had assumed it was part of his lease arrangement. The fourth tenant had actually questioned it once. About 3 years ago, she had called the number on the letterhead and asked why she was paying HOA dues when she was a renter, not a homeowner. She was told that all properties within the association's service area were subject to dues. She had accepted that explanation and continued paying. Service area. Not membership, not recorded covenant, not legal authority. Service area. I now had 4 tenants, combined dues payments running over a decade on some parcels. I needed to know the total. I asked each tenant to provide whatever payment records they still had. Bank statements, money order receipts, anything. What came back over the following 2 weeks was incomplete but significant. Between the 4 tenants, I was able to document over $42,000 in payments to the Creekside Community Association. That was a conservative figure, based only on what the tenants could still prove. The actual total, accounting for years where records no longer existed, was almost certainly higher, $42,000, collected from tenants on land that was never legally part of their association. I called Patricia again. I told her the number. She was quiet for a moment. Then she said we needed to send a formal letter before taking any further steps, a cease and desist, something that put the association on notice and created a legal record of the dispute. I agreed. I told her to draft it. While she worked on that, I kept reading. I pulled the county assessor records for every parcel in Creekside Estates. I pulled the original recorded CC&Rs for the subdivision. I read the Declaration of Covenants in full. It described the association's jurisdiction in specific geographic terms, lot numbers, plat references, recorded boundaries. Gerald's parcels were not listed. Not once. Not anywhere. The association's own founding documents excluded them. Patricia sent the cease and desist letter on a Tuesday morning in October. It was precise and professional. It identified the 4 tenant properties by parcel number. It referenced the county recorder's records. It stated clearly that no recorded covenant, annexation, or legal instrument established any authority by the Creekside Community Association over those parcels. It demanded an immediate halt to all dues collection, all fee assessments, and all lien threats. It requested a written response within 14 days. It also requested a full accounting of all funds collected from the 4 properties going back to the association's founding. We sent it certified mail. We also sent it by email to the contact address listed on the association's website. I did not expect a quick resolution. People who have been operating a certain way for 11 years do not simply stop when asked politely. But I expected acknowledgement. I expected some indication that they had received the letter and were reviewing the matter. 14 days passed. No response. Patricia followed up with a second letter. Shorter. Direct. It noted the failure to respond and stated that we were now preserving all legal options. It gave them 7 additional days. On the 5th day of that second window, I received a phone call. It was not from an attorney. It was from Margaret Hollis herself. Her tone was not apologetic. It was not conciliatory. She was calm in the way that people are calm when they believe they hold authority. She told me she had received our letters. She said she had reviewed the matter with her board. She said the association had been serving those properties for over a decade and that the tenants had always paid without dispute. I let her finish. Then I asked her one question. I asked her to identify the recorded legal instrument that granted the association jurisdiction over those parcels. She said the association serviced the entire surrounding area. I asked again. A recorded instrument, a document filed with the county recorder, a CC&R reference, a plat annexation, anything with a recording number. She said the board had always considered those properties part of the community. I told her that consideration was not the same as legal authority. I told her the association's own recorded CC&Rs did not include those parcels. I told her the county recorder had no document connecting those properties to her organisation. She shifted. She said the tenants had been paying voluntarily for years. She said that established a relationship. I told her that tenants paying under a mistaken belief after receiving letters implying legal obligation did not constitute voluntary agreement. I told her the tenants had never signed any membership documents. I told her they had never received a copy of any CC&Rs because none existed for those parcels. She said she would need to consult with the board again. I told her she had 14 days and had not responded. I told her she now had 48 hours before we escalated. She hung up. I wrote down everything she had said, time of call, duration, every point she made, every response I gave. I saved it in a dedicated folder I had already started for this matter. 2 days later, a letter arrived, not from an attorney, on Creekside Community Association letterhead, signed by Margaret Hollis. The letter did not acknowledge any wrongdoing. It did not offer any refund. What it said was this: the association had provided meaningful community services to the surrounding area for over a decade. It said those services benefited all nearby properties, regardless of formal membership status. It said the dues collected represented fair compensation for those shared services. It said the board was confident in the legitimacy of its operations. It then said something that told me everything I needed to know about how this would proceed. It said that if I continued to pursue this matter, the association would be forced to reconsider the level of services provided to properties in the surrounding area, including road maintenance and drainage work that benefited my tenants. It was a threat, dressed in administrative language, but a threat. They were telling me to drop it, or they would retaliate against my tenants. I read the letter 3 times. Then I scanned it and added it to the folder. I called Patricia and read it to her word for word. She was quiet for a moment. Then she said that letter had just made our case significantly stronger. I asked her to explain. She said that by asserting they provided services that benefited my land, they were implicitly acknowledging that no formal legal relationship existed, because if one did, they would have cited it. And by threatening to withdraw services as leverage, they had potentially crossed into territory that a court would find very uncomfortable. I asked her what our next step was. She said it was time to stop sending letters and start building a file. I have always believed that the person with the better records wins, not the louder person, not the more aggressive person, the one who can produce a document for every claim. I started building that file the same week Patricia told me to. I created a system. Every document went into a dated folder, physical copies and digital scans, every letter, every envelope with a postmark, every email with full headers saved as a PDF, every note from every phone call typed up within an hour of the conversation ending while the details were still precise. I labeled the main folder simply Creekside Matter. Inside it, I built subfolders. One for county records, one for tenant communications, one for association correspondence, one for financial documentation, one for legal research. I started with the county. I drove to the county recorder's office in person. I requested a full search of all recorded documents referencing the 4 parcel numbers on Gerald's eastern edge. The clerk ran the search. It returned deeds, a survey update from 2004, and 2 agricultural use filings. Nothing from the Creekside Community Association. Nothing resembling a covenant or restriction. I paid for certified copies of everything. I asked the clerk to print a search confirmation, a document showing the search terms used and confirming no additional results existed. She said that was not standard. I asked if it was possible. She said yes. I asked her to do it. She did. I added that confirmation to the county records subfolder. Next, I pulled the full recorded CC&Rs for Creekside Estates subdivision. I had already read them once. I read them again, this time with a highlighter. The document defined the association's jurisdiction in Section 2, Article 1. It listed every lot by number. It referenced the recorded plat. It contained a specific provision for annexation of additional properties, a process requiring a written agreement signed by the property owner and recorded with the county. No such annexation had ever been filed for any of Gerald's parcels. I documented that. I created a 1-page summary noting the annexation provision, the absence of any filed annexation for the subject parcels, and the recording numbers of the documents I had reviewed. I attached the relevant pages from the CC&Rs as exhibits. Then I turned to the financial documentation. I contacted each tenant again. I asked them to gather everything: bank statements, cancelled checks, money order stubs, any receipt the association had ever sent. I told them to go back as far as they could. Carl had kept meticulous records. He produced bank statements going back to the month he moved in. Every payment to the Creekside Community Association was clearly listed. 6 years of monthly withdrawals. I totaled them carefully. Carl alone had paid $8,940. Rosa had fewer records. She had bank statements for the past 4 years and partial records before that. What she could document totaled $9,220. Her estimate for the years with missing records added another $3,000 to $4,000 on top of that. The third tenant had limited records. He could document about 3 years of payments, just under $4,000. The fourth tenant, the one who had once called to question the dues, had saved almost everything. She produced 7 years of records, complete, every payment logged. Her total came to $11,300. From those 4 tenants alone, the documented figure was over $33,000. With the gaps filled in by reasonable estimates, the total was closer to $45,000. I built a spreadsheet. Every tenant, every year, every documented payment, every estimated payment with a notation indicating it was an estimate and the basis for the estimate. I kept the documented and estimated figures in separate columns. I did not inflate anything. I kept it conservative and defensible. I then went back further. Gerald had died in March. Before me, he was the landlord. His tenants had been paying these dues for years before I inherited the land. I contacted Patricia and asked if the estate had any obligation to pursue this on behalf of Gerald's prior tenants, some of whom were no longer living at the properties. She said the estate had standing to pursue recovery for the period Gerald owned the land, since the unauthorised collections had occurred on his property and involved his tenants. She said any recovery would flow through the estate and ultimately to me as the sole heir. I asked her to request the association's full financial records as part of any future legal proceeding. She said we were not yet at that stage. She said the next step was a formal demand letter, more detailed than the first, with specific dollar figures attached. I agreed, but I kept building the file. I spent 3 evenings researching HOA law in that state. I am not an attorney. I was not trying to become one. I was trying to understand the framework well enough to ask the right questions. What I found was consistent with what Patricia had told me. An HOA has authority only over properties subject to its recorded governing documents. Dues collection from a non-member property, absent any legal basis, constituted an unjust enrichment claim at minimum. In some circumstances, it could constitute fraud. I wrote that down too. I want to explain something about the documentation process that most people skip over. It is not exciting work. There is no moment of triumph when you scan a letter or organise a spreadsheet. It is slow, it is repetitive, it requires patience that does not feel rewarding in the moment. But documentation does one thing that nothing else can do. It removes doubt. When you walk into any formal proceeding, a mediation, a regulatory hearing, a courtroom, the person with organised, dated, verified records controls the narrative. The other side has to react to your evidence. You do not have to react to theirs. That asymmetry is worth more than any argument. I understood this from my work in logistics. When a shipment goes wrong, the company with complete chain of custody records wins the dispute. Every time. Not because they are louder or more aggressive, because they can prove exactly what happened and when. I applied that same principle here. While I was building the financial documentation, I also began tracking the association's public behaviour. Their website listed meeting minutes going back several years. I downloaded every available document. I read through all of them. What I found was instructive. The minutes were routine for the most part. Budget approvals, landscaping contracts, parking rule updates, the usual administrative content of a small community organisation. But in 3 separate sets of minutes, spanning different years, there were brief references to what the secretary called outlying properties. The first reference was from 7 years ago. It noted that dues notices had been sent to 4 properties on the western boundary and that 2 had responded with payment. The board had voted to continue outreach to the remaining 2. Outreach. That was the word they used. The second reference was from 4 years ago. It noted that all 4 western boundary properties were now current on dues. The board had approved a motion to maintain those properties on the standard billing cycle. Maintain. Standard billing cycle. The third reference was from 18 months ago. It noted that one Western Boundary property had questioned its dues obligation. The board had voted to send a clarifying letter affirming the association's service area and the dues requirement. That was the tenant who had called, the one who had asked why she was paying. The board had documented her question and voted to send a letter pushing back. They had discussed these properties multiple times, over multiple years, in recorded meeting minutes. That told me this was not an administrative error that had gone unnoticed. The board was aware of these properties. They had actively monitored payment. They had voted on responses when questions arose. They had maintained these tenants on their billing cycle deliberately. I downloaded all 3 sets of minutes. I highlighted the relevant passages. I added them to the documentation file with a summary noting the dates, the specific language used, and what each entry demonstrated. Then I looked at something else. The association had a management company, a small firm that handled billing, correspondence, and record-keeping on behalf of the board. Their name appeared on most of the formal letters sent to my tenants. I looked them up. They were a legitimate operation, licensed, in business for many years. They handled several HOA accounts in the region. I noted their name and contact information. I did not contact them yet, but I kept them in mind. Patricia sent the second formal demand letter in mid-November. This one was detailed. It listed every parcel by number. It cited the CC&Rs by recording number and quoted the jurisdictional language. It cited the annexation provision and confirmed no annexation had been filed. It attached the county recorder's search confirmation. It listed the documented financial figures by tenant with a total demand of $45,800, the combined documented and estimated figure clearly labelled. It demanded full repayment within 30 days. It also stated that failure to respond or comply would result in legal action and a complaint to the state's HOA regulatory authority. I had not known there was an HOA regulatory authority until Patricia mentioned it. I asked her to tell me more. She explained that the state had a division within the Real Estate Commission that handled complaints against HOAs. It had limited enforcement power, but it could investigate, issue findings, and refer matters to the Attorney General's office if it found evidence of systematic violations. A regulatory complaint, even if it did not result in direct monetary recovery, could create significant pressure on the association and produce additional documentation through the investigation process. I told her to include that reference in the letter. She had already written it in. We sent the second demand letter on a Wednesday. Certified mail, email with read receipt. I kept copies of everything. Then I waited. This time the response came faster. The response came 9 days after we sent the second demand letter. This time it was from an attorney. His name was Dennis Pruitt. He represented the Creekside Community Association. His letter was 4 pages long. It was written in the formal language of someone who expected it to be taken seriously. I read it carefully. The letter made 3 central arguments. The first argument was that the tenants had paid voluntarily for years without objection, establishing what Pruitt called a course of dealing. He argued this course of dealing created an implied agreement between the tenants and the association. He cited 2 cases. The second argument was that the association had provided genuine services that benefited the surrounding area, road maintenance, drainage management, and community upkeep, and that the dues collected were reasonable compensation for those services, whether or not a formal legal relationship existed. He used the phrase quantum meruit, compensation for value received. The third argument was that my demand letter had been sent after the property transferred to me through inheritance and that I lacked standing to seek recovery for payments made to the prior owner's tenants over prior years. I read all 3 arguments twice. Then I called Patricia. She had already read the letter. She had notes ready. On the first argument, course of dealing, she said it was weak. Course of dealing typically applies to commercial contracts between parties who have negotiated terms. It does not apply when one party pays under a mistaken belief created by the other party's misrepresentation. The tenants had been told they were obligated to pay. They had not chosen to pay in exchange for something they valued. They had paid because they believed they had to. That distinction mattered. On the second argument, quantum meruit, she said it was more serious but still limited. Quantum meruit allows recovery for services actually rendered when no contract exists, but it requires that the services were requested or knowingly accepted. My tenants had never requested HOA services. They had never been asked whether they wanted them. The association had simply provided services to the surrounding area and then billed people who had no say in the matter. That was not quantum meruit. That was unilateral imposition. On the third argument, standing, she said it was partially correct but mostly irrelevant. The estate had standing going back through Gerald's ownership period. I had standing for the period since I inherited. The combination covered the full timeline. She said Pruitt's letter was what she expected from an attorney defending a weak position. It raised technical arguments to create delay and uncertainty. None of them were fatal to our case. I asked her what we should do. She said we had two options. We could respond to Pruitt's letter with a rebuttal and attempt to negotiate a settlement, or we could file suit and let the process do the work. I asked which she recommended. She said one more exchange first. She wanted to send a response that addressed each of Pruitt's arguments directly, attached additional documentation, and made clear we were prepared to litigate. She said sometimes attorneys back down when they realize their client has no good defense. She wanted to give Pruitt one opportunity to counsel his client toward a reasonable resolution. I agreed. Patricia spent a week preparing the response. It was thorough. It addressed the course of dealing argument with case law, showing that payments made under mistaken belief do not constitute voluntary agreement. It addressed the quantum meruit argument by noting that the services cited were performed for the subdivision itself, not for my tenants, and that my tenants had never requested, contracted for, or consented to receive them. It addressed the standing argument by attaching the estate documents showing the full chain of ownership and the scope of recovery we were pursuing. It also attached 3 additional documents. The first was the county recorder's search confirmation, the one I had specifically requested, showing no recorded instrument connected Gerald's parcels to the association. The second was a highlighted excerpt from the association's own CC&Rs, showing the annexation provision and confirming no annexation had been filed. The third was the 3 sets of meeting minutes I had found on the association's website. The ones showing the board had discussed the outlying properties, monitored their payments, and voted on responses to tenant questions over multiple years. Patricia's cover note to Pruitt was brief. It said the documentation attached demonstrated that the association had knowingly collected dues from properties outside its legal jurisdiction for over a decade. It said the meeting minutes showed this was not an error. It said we were prepared to present this evidence in court and to the state regulatory authority. It invited settlement discussions within 21 days. I signed the authorization for Patricia to send it. We sent it on a Monday. By Thursday, Pruitt had called Patricia. He said his client wanted to discuss resolution. Patricia called me with the news. She kept her voice professional, but I could hear something behind it. The documentation had done exactly what good documentation does. It had removed the other side's ability to claim ignorance, mistake, or ambiguity. They knew we had the minutes. They knew we could prove this was deliberate. They knew that a court would see those minutes the same way we did. I told Patricia to proceed with the conversation, but I told her to make clear that any resolution had to include full repayment of all documented funds, a formal written acknowledgement that the association had no authority over those parcels, and a commitment to cease all future contact with my tenants regarding dues. She said she would convey that. I added one more condition. I said I also wanted their cooperation in identifying the full scope of collections going back to the beginning. Not just what my tenants could document, the association's own records. Every payment they had received from those 4 properties since the first dues notice was ever sent. Patricia said that would likely require a subpoena if they did not agree voluntarily. I told her that was fine. We would get there either way. The settlement conversation did not go smoothly. Pruitt came back to Patricia with a counter-proposal. It was not a serious offer. It proposed paying back 6 months of dues per tenant, a total of roughly $2,600. It included no written acknowledgement of wrongdoing. It included a mutual release clause that would have prevented me from pursuing any further action or filing any regulatory complaint, $2,600 against a documented $45,000, and a gag clause on top of it. I told Patricia to decline. I told her to decline clearly and without leaving any room for interpretation. She did. Pruitt came back a second time 2 weeks later. The new offer was better but still inadequate. He proposed $12,000, roughly 1/4 of the documented amount, again with a release clause and again with no written acknowledgement. I declined again. Patricia asked me at that point whether I wanted to proceed directly to litigation or whether I wanted to try one more approach first. She said she had been thinking about the management company, the billing firm that handled correspondence on behalf of the board. I had noted that company months earlier and set them aside. Now Patricia brought them back into focus. She explained her thinking. The management company had sent the dues notices. They had processed the payments. They had sent the lien threat letter. As a professional operation, licensed, experienced, managing multiple HOA accounts, they carried a different level of responsibility than a volunteer board. A licensed management company is expected to know the legal boundaries of HOA authority. Sending dues notices and lien threats to properties outside recorded jurisdiction was not a minor clerical matter for them. It was a professional failure with potential licensing consequences. She suggested we contact the State Real Estate Commission, the same body that oversaw HOA regulatory matters, and file a complaint not just against the association but against the management company specifically. I asked her what that would accomplish. She said 2 things. First, a complaint against a licensed company creates immediate pressure. Their license is their livelihood. A regulatory investigation, even if it results in nothing more than a warning, is something they cannot ignore. Second, a licensed company under regulatory scrutiny has strong incentive to cooperate. They might produce records, complete billing records going back to the beginning, that we could not easily obtain any other way. I thought about that for a day. Then I told her to proceed. But before we filed the regulatory complaint, I wanted to do one more thing. I wanted to attend a Creekside Community Association board meeting. Their meeting schedule was posted on the website. The next regular meeting was 3 weeks away. The meetings were open to residents. The agenda was posted in advance. I was not a resident of Creekside Estates, but the association had been billing my tenants for 11 years. I had a direct financial interest in their operations. I believed I had standing to attend as an affected party. I called the number on the website and asked whether non-residents with a financial interest in association matters could attend board meetings. The person who answered, not Margaret, a younger-sounding woman, said the meetings were open to all property owners in the service area. Service area. That phrase again. I thanked her and noted the date. I told Patricia my plan. She advised me to attend quietly. Observe. Take notes. Do not confront. Do not argue. Do not identify myself as the person behind the demand letters unless directly asked. Simply be present. Let them operate normally. Watch how they conduct themselves. I agreed to those terms. I drove to the meeting on a Tuesday evening in December. It was held in a community room inside the subdivision's clubhouse. About 15 people attended. Most were homeowners discussing routine matters, landscaping bids, holiday lighting rules, a drainage issue on the north end of the development. Margaret Hollis ran the meeting. She was composed and organised. She moved through the agenda efficiently. She was clearly experienced at running these sessions. Near the end of the meeting, under new business, she mentioned that the association had received legal correspondence regarding certain properties on the western boundary. She did not use my name. She said the board was handling the matter with legal counsel and that it was not expected to affect the association's operations or finances. Not expected to affect finances. I wrote that down. After the meeting, I introduced myself to Margaret directly. I was calm. I shook her hand. I told her my name and that I had recently inherited the land on the western boundary. I told her I was hoping we could find a reasonable resolution. She smiled. She said she was sure it would all work out. She said these things sometimes took time. I thanked her and left. In the parking lot, I sat in my car and wrote down everything I had observed. Her exact words about the western boundary matter. Her tone. The fact that she had disclosed it to the room without detail. The fact that she had described it as not expected to affect finances despite the $45,000 demand sitting on her attorney's desk. That last part told me something important. She still did not believe we were serious. I filed the regulatory complaint the following week. I filed it against two parties simultaneously, the Creekside Community Association and their management company, a firm called Reliable Community Services, LLC. The complaint was detailed. Patricia helped me draft it, but the substance came from the file I'd been building for months. It laid out the full timeline. It attached the county recorder's search confirmation. It attached the CC&R excerpts with the jurisdictional language highlighted. It attached the annexation provision with a note confirming no annexation had ever been filed. It attached the 3 sets of meeting minutes showing the board's awareness of the outlying properties over multiple years. It attached the financial documentation showing over $45,000 in collections. For Reliable Community Services specifically, the complaint noted their professional licensing obligations. It noted that as a licensed HOA management company, they were responsible for ensuring dues notices were sent only to properties within the association's legal jurisdiction. It noted that they had sent those notices for years, including the lien threat letter, without apparent verification of legal authority. I submitted the complaint online. I received an automated confirmation with a case number. 3 days later, I received a phone call from a regulatory investigator. Her name was Sandra. She was professional and methodical. She asked me to walk her through the complaint. I did. She asked clarifying questions. I answered each one and offered to send additional documentation for anything she needed. She said the investigation would take 60 to 90 days. She said both parties would be notified and given opportunity to respond. She said I would receive updates as the process moved forward. I thanked her and added the call to my documentation log. Within 2 weeks of the regulatory complaint being filed, something changed. Pruitt called Patricia again. His tone was different this time. The previous calls had been measured and slightly dismissive, the tone of an attorney who believed his client had reasonable defences and time on their side. This call was different. He was still professional, but the dismissiveness was gone. He said his client was prepared to have a more serious conversation about resolution. Patricia asked him to define serious. He said they were prepared to discuss a figure in the range of $20,000. Patricia told him that was not serious. She told him our documented figure was $45,000 and our estimated total was higher. She told him we had filed a regulatory complaint that was now under active investigation. She told him we had not yet filed suit but were prepared to do so. Pruitt asked for 2 weeks to consult with his client. Patricia said 1 week. He agreed. During that week, I did something I had been considering for some time. I contacted the tenants who had left the properties before I inherited the land. Gerald had kept basic records, names, lease periods, contact information. Some were traceable, some were not. I found 3 former tenants I could reach. I explained the situation to each of them. I told them the association had collected dues from the properties during their tenancy without legal authority. I told them I was pursuing recovery and that if they had any payment records, their documented amounts could be included in the claim. 2 of them had records, partial but usable. 1 had almost nothing but remembered paying for several years and could provide an estimate with supporting context. I added their information to the file. The documented total climbed past $50,000 when their records were included. The full estimated total, including gaps across all tenants past and present, was somewhere between $60,000 and $70,000. I updated the financial spreadsheet. I kept the documented and estimated figures in separate columns as always. I did not inflate anything. Every figure had a notation explaining its basis. At the end of the week, Pruitt called back. He offered $30,000. No release clause this time, but still no written acknowledgement of wrongdoing. Patricia conveyed the offer to me. I said no. I told Patricia to tell Pruitt we were filing suit the following Monday unless we received a written offer of full documented recovery, $50,000 minimum, with a formal written acknowledgement that the association had no legal authority over those parcels. A commitment to cease all contact with current and former tenants and full cooperation in producing their complete billing records going back to the association's founding. Patricia asked me if I was certain about the Monday deadline. I told her I was. She conveyed the message. Sunday evening, Pruitt called her at home. He said his client wanted 1 more day. Patricia told him Monday morning, 9 o'clock. At 8:53 on Monday morning, Pruitt sent an email. His client was prepared to meet our terms, with one modification. They wanted 60 days to produce the complete billing records rather than 30. I read the email, I looked at the clock, I thought about it for 4 minutes. Then I told Patricia to accept the 60 days on the records and confirm the rest of the terms in writing before close of business that day. She did. By 4 in the afternoon we had a signed term sheet, but I did not celebrate. A term sheet is not a settlement agreement. It is not money in hand. It is not a signed acknowledgement filed with the court. It is a piece of paper expressing intention. I had been building this file for months. I was not going to stop now. The term sheet held for about 3 weeks. Then Pruitt sent a letter walking portions of it back. He said his client had reviewed the signed terms with the full board and that several members had concerns about the written acknowledgement clause. He said the board was willing to pay but was not willing to sign any documents stating the association had acted without legal authority. He said such an acknowledgement could expose the board members to personal liability beyond the settlement itself. He was not wrong about that, but it was not my problem. I read his letter carefully. Then I called Patricia. She said what I already knew. The acknowledgement clause was not optional for us. Without it, the association could resume billing the moment the settlement was paid. They could claim the payment was simply a goodwill gesture. They could argue the matter had been resolved without any finding of wrongdoing. The acknowledgement was the mechanism that prevented that. I told her to send Pruitt one response. It would state that we were proceeding to file suit on Friday of that week unless the full term sheet was honoured, without modification. No further negotiation. She sent it. Friday came. No response from Pruitt. Patricia filed suit that afternoon. The complaint named the Creekside Community Association as the primary defendant. It named Reliable Community Services, LLC, as a secondary defendant. It stated claims for unjust enrichment, negligent misrepresentation, and intentional misrepresentation. It sought full recovery of all documented and estimated funds collected without legal authority, plus attorney's fees, plus injunctive relief permanently barring the association from any future contact with the subject parcels. The filing was public record. I had not planned what happened next. It was not part of any strategy. It was simply the nature of public records in a small county. A local journalist found the filing. She covered municipal and community affairs for a regional news outlet. She contacted Patricia asking for comment. Patricia called me. I thought about it for 1 day. Then I told Patricia I would speak to the journalist briefly and on the record. I gave a short interview. I did not exaggerate anything. I described the situation factually. 11 years of dues collection. Land never subject to HOA authority. Documented amounts. Regulatory complaint filed. Lawsuit now pending. I spoke for about 12 minutes. I answered her questions directly. I did not editorialize. I did not call anyone names. I described what had happened and what the documents showed. The article ran 4 days later. The headline used the phrase unauthorized dues collection. The article described the lawsuit, the regulatory complaint, and the core facts of the case. It quoted me briefly. It quoted Patricia briefly. It noted that the association and their attorney had not responded to requests for comment. I did not share the article myself. I did not post it anywhere. I did not send it to anyone. Other people did. Within 48 hours, the article had circulated through several community Facebook groups in the county. Homeowners in Creekside Estates began commenting. Most were surprised. Some were angry, not at me, but at the board. Several said they had never been informed about any of this. Several asked why the board had not disclosed the lawsuit at the last meeting. Margaret had told the room the matter was being handled and was not expected to affect finances. Now there was a lawsuit, a regulatory investigation, and a newspaper article. 3 Creekside homeowners contacted Patricia directly. They said they had questions about the board's handling of HOA funds. They asked if they had any standing in the matter. Patricia explained she represented my interests only, but suggested they review the association's financial disclosures and meeting minutes and consult their own attorney if they had concerns. 2 of them apparently did exactly that. Within 2 weeks of the article running, I received a copy of a letter that had been sent to the full Creekside Estates membership. It was signed by 3 board members, not including Margaret. It stated that the board had become aware of a legal dispute involving properties on the western boundary. It said the board was reviewing the matter carefully. It said a special membership meeting would be scheduled to provide a full update. Margaret had not signed that letter. I noted that carefully. Then I received something unexpected. A phone call from a woman named Diane. She identified herself as a Creekside Estates homeowner and a former board treasurer. She said she had left the board 4 years ago. She said she had raised concerns at that time about the western boundary properties. She said she had questioned whether those properties were legitimately subject to dues and had asked the board to obtain a legal opinion. She said the board had voted to table the matter. I asked her if she had any documentation of that. She said she had kept her personal notes from board meetings during her time as treasurer. She said she would be willing to share them if it would help. I told her it would help significantly. She mailed me a folder the following week, handwritten notes, dated, covering 14 months of board meetings during her tenure. In 3 separate entries, she had noted her concerns about the western boundary properties and the board's response. In one entry, she had written a single line that I read several times. It said, "Motion to obtain legal opinion re western parcels. Motion failed. MH opposed. March. Margaret Hollis." Margaret had opposed obtaining a legal opinion on the very question that was now at the centre of a lawsuit. I scanned every page of Diane's notes. I added them to the file. I called Patricia and read her the relevant entries. She was quiet for a moment. Then she said those notes had just changed the character of the case. The lawsuit moved through its early stages steadily. Pruitt filed a response on behalf of the association. It raised the same arguments his earlier letters had made. Course of dealing, quantum merit, standing. The response was competent, but it contained nothing new. He had no new facts. He had no new documents. He was working with the same weak foundation he had started with. Reliable Community Services filed a separate response through their own attorney. They argued they had acted solely as an agent of the association and bore no independent liability. They said all decisions about which properties to bill had been made by the board. They said they had simply executed instructions. That argument had some legal merit, but it also had a limit. A licensed professional cannot execute clearly improper instructions without consequence. That question would be resolved through discovery. Discovery began 6 weeks after the responses were filed. Patricia submitted document requests to both defendants. She requested all billing records for the 4 subject parcels going back to the association's founding. She requested all board communications referencing the western boundary properties. She requested all communications between the board and Reliable Community Services regarding those properties. She requested the association's complete financial records for the past 12 years. The defendants had 30 days to respond. While we waited, Patricia deposed Margaret Hollis. I attended the deposition. I sat quietly at the end of the table and took notes. I did not speak. I watched. Margaret arrived composed. She had clearly been prepared by Pruitt. She answered early questions carefully. She confirmed her role. She confirmed her years on the board. She confirmed she was familiar with the western boundary properties. Then Patricia began working through the documents. She showed Margaret the CC&Rs. She asked Margaret to read the jurisdictional section aloud. Margaret did. Patricia asked her whether the western boundary parcels were listed in that section. Margaret said they were not. Patricia asked her whether an annexation had ever been filed for those parcels. Margaret said she was not certain. Patricia showed her the county recorder's search confirmation. She asked Margaret whether she now had certainty. Margaret said it appeared no annexation had been filed. Patricia showed her the meeting minutes, the 3 entries referencing the outlying properties. She asked Margaret to confirm the board had discussed those properties on those dates. Margaret confirmed it. Patricia asked her whether the board had ever obtained a legal opinion on whether those properties were subject to the association's jurisdiction. Margaret said she did not recall. Patricia showed her Diane's notes, the entry about the motion to obtain a legal opinion, the notation that the motion had failed, the initials MH beside the opposition. Margaret looked at the notes for a long time. She said she did not recall that specific motion. Patricia asked her whether the initials MH in a former treasurer's contemporaneous meeting notes referred to her. Margaret said she could not be certain whose initials those were. Patricia moved on without pressing further. She had made her point. The jury would see those notes. The jury would see Margaret's answer. The document production came in 38 days after the requests were submitted. It was substantial. Reliable Community Services produced complete billing records, every dues notice sent to the 4 western boundary parcels going back to the beginning. The records were organised by property and by year. They were complete. I sat with Patricia and went through them over 2 full days. The total was worse than we had estimated. The association had begun billing the western boundary properties in the 2nd year of the subdivision's existence. The first notices had gone out 11.5 years ago. The initial dues amount was $40 a month per property. It had been raised 7 times over the years. The most recent amount was $110 per month. The complete billing total across all 4 properties for the full period was $81,420. $81,000. Our documented recovery from tenant records had been around $50,000. The complete records showed the actual number was 60% higher. I wrote that figure down carefully. I checked it 3 times against the records. Patricia filed an amended complaint updating the damages figure to reflect the complete billing records. She added a claim for punitive damages based on the evidence of deliberate, long-term collection from properties the board knew were outside their jurisdiction. Pruitt filed for a continuance. He said his client needed additional time to prepare given the amended complaint. The judge granted 60 days. During those 60 days, 2 things happened. The first was that the state regulatory authority issued its preliminary findings. The investigation had concluded that the Creekside Community Association had collected dues from properties outside its recorded jurisdiction for over 11 years. The findings cited the same documents we had filed with the court. The regulatory authority issued a formal notice of violation to the association and a separate notice to Reliable Community Services citing failure of professional due diligence. Neither notice carried an immediate financial penalty, but both were now part of the public record, and both would be referenced in any future licensing review. The second thing that happened was that Margaret Hollis resigned from the board. No announcement, no explanation. Her name simply disappeared from the association's website. The 3 board members who had sent the membership letter without her signature confirmed at the special membership meeting that she had stepped down. I noted the timing. Regulatory findings issued. Amended complaint filed with punitive damages. Resignation followed within 2 weeks. Pruitt contacted Patricia the day after the membership meeting. He said his client wanted to resolve the matter. Patricia told Pruitt we were listening. He proposed a full settlement. The number he put forward was $65,000. He said it represented the documented billing total minus a reduction for the quantum meruit argument, the services the association claimed had benefited the surrounding area. Patricia told him we were not accepting any reduction for quantum meruit. She told him the amended complaint sought $81,000 in direct recovery, plus punitive damages, plus attorney's fees. She told him a reduction for services my tenants never requested was not a concession we were prepared to make. Pruitt said punitive damages were unlikely to be awarded given the association's non-profit status. Patricia told him that was an argument for the court to evaluate and that we were prepared to make that argument in front of a jury. There was a pause on the line. Pruitt asked what number would resolve the matter. Patricia told him, full billing recovery of $81,420, attorney's fees of $14,000, a signed, notarized acknowledgement that the association had collected dues from properties outside its legal jurisdiction without authorization, a permanent injunction barring any future contact with the subject parcels regarding dues, fees or assessments, and full cooperation with the regulatory authority's ongoing process. Total monetary settlement, $95,420. Pruitt said he would take it to his client. He called back in 4 days. His client accepted. Every term, the full monetary amount, the acknowledgement, the injunction, the regulatory cooperation. I received the call from Patricia on a Thursday afternoon. I was at my desk at work. I thanked her. I told her she had done excellent work. I hung up and sat quietly for several minutes. I did not feel triumph. I felt something quieter than that. The feeling of a process completing the way a process should complete when it is built on solid ground. The settlement agreement was drafted over the following 2 weeks. Patricia reviewed every line. I reviewed every line. The acknowledgement clause was precise. It stated clearly that the Creekside Community Association had collected dues assessments from 4 specifically identified parcels listed by county parcel number over a period of 11.5 years without any recorded legal authority to do so. It stated that those parcels had never been subject to the association's CC&Rs. It stated that no annexation had ever been filed. It stated that the association acknowledged these facts and agreed to make no future assessment against those parcels. It was signed by the current board president, not Margaret, who had resigned, and notarized. I had that document filed with the county recorder, the same county recorder's office where, months earlier, a clerk had run a search and found nothing connecting those parcels to the association. Now there was a recorded document. It would appear in any future title search. Anyone who looked would find it. The monetary payment arrived by wire transfer on the agreed date. I split the recovery proportionally among the tenants based on their documented payments. Carl received the largest share. Rosa received the second largest. The former tenants who had provided records received their portions. Every person who had paid received something back. I kept nothing beyond the recovery of attorneys' fees and the administrative costs I had absorbed over the past year. That had never been the point. The regulatory process concluded 3 months after the settlement. The State Real Estate Commission issued final findings against both the Creekside Community Association and Reliable Community Services, LLC. The association received a formal censure and was required to complete a compliance review of all its billing practices. Reliable Community Services received a formal reprimand entered against their license. They were required to implement verification procedures confirming legal jurisdiction before sending dues notices to any property. Neither outcome carried large financial penalties, but both were permanent entries in public records. I checked the Creekside Community Association's website 6 months after the settlement. The board had new members. The meeting minutes had resumed their routine content: landscaping, parking, maintenance schedules. There was no mention of the western boundary properties anywhere on the site. Donna, my property manager, confirmed that no further correspondence had been received from the association. The tenants confirmed the same. The billing had stopped completely. Carl called me about 4 months after the settlement funds were distributed. He thanked me. He said he had never questioned the dues notices because he assumed they were legitimate. He said he felt foolish about that. I told him he should not. I told him the notices were designed to look legitimate. I told him he had done nothing wrong. He asked me one question before we hung up. He asked what made me pursue it rather than just settle early and move on. I told him the truth. I told him it was the meeting minutes. Once I saw that the board had discussed those properties over multiple years, had monitored the payments, had voted on responses, had blocked a motion to get a legal opinion, I knew this was not a mistake. Mistakes get corrected when someone points them out. This had continued for 11 years after it started and kept going after we sent the first letter. That is not a mistake. That is a decision. And decisions have consequences. I think about Gerald sometimes. He was a careful man. He read everything twice. He never joined anything he did not have to. He farmed his land quietly for decades and asked very little of anyone. I do not know if he ever received a dues notice from the Creekside Community Association. If he did, I believe he would have questioned it. I believe he would have pulled out the deed and read it. I believe he would have called the county recorder and asked questions. But Gerald died before I inherited the land. Whatever he knew or did not know went with him. What I know is this: 11.5 years, 4 tenant properties, $81,000 collected without legal authority, a board that discussed it in meetings, monitored it actively, blocked a motion to verify it legally, and kept sending notices when questioned. None of that happened because of one bad person. It happened because of a system that was never checked. The tenants assumed the notices were legitimate. The property manager before Donna assumed someone else had verified it. Gerald may never have seen the notices at all. The management company executed instructions without asking hard questions. The board raised dues 7 times over 11 years, and nobody stopped to confirm they had the right to do that. Systems like that persist through assumptions. Everyone assumes someone else already verified the thing that no one ever actually verified. The only way to stop them is documentation. Not anger, not confrontation, not noise, records, dates, certified copies, recorded documents, a spreadsheet with two columns, one for what you can prove and one for what you can only estimate, and the discipline never to confuse the two. I am not a lawyer. I am not a farmer. I am a logistics manager who inherited land he did not expect and discovered a problem he did not go looking for. But I knew how to build a file. I knew how to read a document. I knew how to ask a simple question and write down the answer. That was enough. If you own land, read your deed. Read your title report. If someone sends you a bill, ask them to show you the legal authority behind it. Not aggressively, not with anger. Simply ask. Request the document. Request the recording number. Request the evidence. Most of the time, the authority is real and the document exists. But sometimes it does not. And the only way to know the difference is to ask. Gerald's land is still there. 900 acres. Quiet, wide and unbothered. The way he kept it. The way I intend to keep it. The HOA does not send letters there anymore.
11.5 years, 4 tenants, $81,000 taken from land they had no right to touch. And there is the part that stay with me. The board knew it is right there in on their meeting notes. They watched those payments come in every month. They even blocked someone from checking if it was legal. One line written by hand said it all motions failed MH export. Margaret did not make a mistake. She made a choice. Every single month for 11 years, she almost got away with it because of one reason everyone assumes someone else had already looked into it. The tenant thought the bill was real. The property's manager thought it has been checked. Nobody stopped it to ask one simple question. Can you show me the paperwork? That is all it took. Not a big law firm, not a lot of money, just one person who read the document and asked for proof. If this felt familiar, share it someone you know is properly paying a bill they were never exposed to gas subscribe. Next week, an HOA sent a man a $30,000 fine over a garden on his own land. He fights back, and the ending nobody saw coming. See that.